Welcome to California Rural Legal Assistance Know Your Rights presentation on post-conviction record clearing. We provide post-conviction record clearing services for expungement, arrest record sealing, felony reduction, and early termination of probation. You may be eligible for expungement if you are not currently serving a sentence for any offense in any jurisdiction, you are not currently facing criminal charges for any offense in any jurisdiction, if you were convicted of a felony or misdemeanor offense where probation was granted, if you were convicted of a misdemeanor or an infraction offense where probation was not granted, or if you were convicted of a felony offense and were sentenced to felony jail pursuant to Penal Code Section 1170H or state prison. If you were convicted of a felony offense and were sentenced to state prison, it must be more than 2 years since the completion of your prison sentence, which includes supervision, which would be post-community release or parole. And that offense must not require you to register as a sex offender pursuant to Penal Code Section 290. If you were convicted of a felony or a misdemeanor offense where probation was granted, you will be eligible for expungement so long as you were not convicted of the following offenses: Vehicle Code Section 2800, 2801, or 2803, Penal Code Section 286C, Penal Code Section 288, Penal Code Section 287C, Penal Code Section 288.5, Penal Code Section 289J, Penal Code Sections 11.1, 11.2, 11.3, or 311.11. Finally, a felony conviction of Penal Code Section 261.5D. All other offenses will be eligible. If you have fulfilled the conditions of probation for the entire period without violation, or if your probation term was terminated early for good conduct, you will be entitled to relief. If you were convicted of a misdemeanor or an infraction offense where probation was not granted, you may be eligible for expungement if your conviction was not one of the following offenses: Vehicle Code Section 2800, 2801, or 2803, or Penal Code Section 288C, and any traffic infraction will not be eligible for expungement. For a misdemeanor or an infraction conviction where probation was not granted, 1 year must pass since the sentencing date, and you must have fulfilled completely and complied with the sentence of the court to be eligible. If you have not been arrested or convicted within 1 year from your sentencing date, you will be entitled to relief. If you were convicted of a felony offense and were sentenced to felony jail pursuant to Penal Code Section 1170H5A or Penal Code Section 1170H5B or state prison, you may be eligible for relief. If you were convicted of a felony offense where the sentence was Penal Code Section 1170H5A, more than 2 years must pass since the completion of that sentence. If you were sentenced to felony jail pursuant to Penal Code Section 1170H5B, more than 1 year must pass since the completion of mandatory supervision. And if you were convicted of a felony offense and sentenced to state prison, more than 2 years must pass since the completion of the sentence, which includes post-release community supervision or parole. If you were sentenced to state prison, your offense must not require you to register as a sex offender pursuant to Penal Code Section 290 to be eligible for relief. Let's talk about arrest record sealing. If you were arrested and a conviction did not occur, you may be eligible for arrest record sealing if you were arrested but no charges were filed and the statutes of limitations for each offense on the complaint has run. If you were arrested and charged but charges were dismissed, and for felony arrests the statutes of limitations has run. If you were arrested but diversion was completed and the charges were dismissed, or if you were arrested, went to trial, and were found not guilty. you will be eligible for arrest record sealing. Let's talk about felony reduction. There are 3 types of felony reduction. Penal Code Section 17B for wobbler offenses, which are certain offenses that can be charged either as a felony or a misdemeanor. Proposition 47 and Proposition 64. If you qualify for felony reduction under one of these sections, we will simultaneously request felony reduction and expungement of your offenses on that complaint. Let's talk about eligibility for felony reduction pursuant to Penal Code Section 17B. You may be eligible for felony reduction pursuant to Penal Code Section 17B if you were convicted of a wobbler offense and you were not sentenced to state prison or felony jail pursuant to Penal Code Section 1170H5A or B. Let's talk about felony reduction pursuant to Proposition 47. You may be eligible for felony reduction pursuant to Proposition 47 if you were convicted of any of the following offenses as a felony. Penal Code Section 459, second-degree burglary. Penal Code Section 473, forgery not exceeding $950. Penal Code Section 476A, writing a bad check not exceeding $950. Penal Code Section 490.2, theft where the value does not exceed $950. Penal Code Section 496A, receipt of stolen property where the value does not exceed $950. Penal Code Section 666 for petty theft with a prior, or Health and Safety Codes 11350, 11357, or 11377 for possession of a controlled substance. Let's talk about Proposition 64. You may be eligible for felony reduction pursuant to Proposition 64 if you were convicted of any of the following offenses as a felony. Health and Safety Code 11357, Health and Safety Code 11358, Health and Safety Code 11359, Health and Safety Code 11360, Health and Safety Code 11362.1, .2, .3, or .4. Let's talk about early termination of probation. You may be granted early termination of probation if you have served at least half of your probation term, and we see this across the benches throughout the state of California, where most judges are looking for you to have completed at least half of your probation term to be considered a good candidate for early termination of probation, but it's not required. Judges are looking for you to have completed all of the conditions of your probation, including but not limited to serving any jail time if ordered, completing any classes if ordered, paying all fines and fees if ordered, and paying all victim restitution if ordered. Additionally, the court will want to confirm that you did not suffer any probation violations during your probationary period, you are not serving a sentence for any offense in any jurisdiction, and you're not currently facing any criminal charges in any jurisdiction. If you are a good candidate for pursuing early termination of probation, we will simultaneously request early termination of probation and expungement of your offense. The benefits of post-conviction record clearing include increased job prospects, housing prospects, the ability to obtain or restore a professional license, the ability to restore gun rights in certain circumstances, and personal satisfaction. We will need from you a letter to the court, and this is a direct line of communication between you and the judge that will be deciding your case. Your letter to the court should include the following information: the circumstances in your life at the time of the conviction or convictions, including addiction issues, homelessness, mental health challenges, etc. Changes you have made since the conviction, including in education, employment, programming, housing, sobriety, therapy, etc. All demonstrated rehabilitation. And finally, why a clear criminal record is going to help you with your stability. So why you are seeking post-conviction relief. We would also like you to gather some supporting documents to strengthen your petition packet, such as proof of payment of court fines and fees, if any, proof of payment of victim restitution, if any was ordered, proof of employment, certificates of proof of completion of any programming, including court-ordered programming, any diplomas or degrees, proof of community service, and any letters of support from friends, family, employers, colleagues, etc. These are just examples of documents that would be helpful in seeking post-conviction relief. You are not required to obtain all of these documents, but the more the better. First stop is to call our office at 209-859-0519 or email bmccone@sierralea.org for intake, after which we can request your rap sheet from the Department of Justice, analyze your rap sheet for eligible convictions to pursue post-conviction remedies, assist you with your letter to the court and collecting any supportive documents, and finally drafting and filing your petition in the Superior Court in the county that you had a conviction or arrest. Thank you for joining us. We look forward to meeting you and helping you with your post-conviction needs.